Welcome to The Explainer. If you're a finance or accounting professional in India, you know that the numbers, they're really only part of the picture. Today, we're going to unpack the legal rulebook that shapes every single business decision you make. Okay, so let's just jump right in with a pretty fundamental question. If your world is all about numbers, data, and strategy, why on earth should you care about the Indian Constitution? I mean, it's a legal document from 1950. What does that have to do with your job today? Well, the answer comes straight from the CMA's own playbook. It's because business doesn't happen in a bubble, right? To be really good at what you do, to spot opportunities and think critically, you absolutely have to understand the rulebook that governs the entire game. So, here's our game plan for today. We're going to start with the big picture, the Constitution's blueprint. Then we'll zoom in on the rights that it guarantees you. We'll look at where our everyday laws actually come from, how to handle disagreements without a big court battle, and finally, we'll tie it all together to solve a practical case. All right, first up, the master document itself. We're starting right at the beginning with the Constitution's powerful mission statement, the preamble. The preamble isn't just some fluffy intro paragraph. It's really the heart and soul of the whole document. In just a few lines, it lays out everything. Where the power comes from, that's we the people, the freedoms it promises, and the kind of nation India sets out to be. And listen, this isn't just for show. In a massive landmark case, Kesavananda Bharti, the Supreme Court made it crystal clear that the preamble is a core guiding part of the Constitution. Think about that for a second. That means every law, every regulation can be measured against this grand vision. It's the ultimate yardstick. Okay, so that's the big vision, but how does that actually translate into real, concrete protections for you and me? Well, that brings us to our next section, your guaranteed fundamental rights. All right, pop quiz time. This is the kind of thing you might see pop up on an exam. True or false? Fundamental rights are not enforceable in the court of law in India. What do you think? If you said false, you are absolutely correct. The answer is a big, resounding false. And the reason is Article 32. This thing is a game changer. It's not just another right. It's a guaranteed right to go straight to the Supreme Court if any of your other fundamental rights are violated. It's what gives all those other rights real teeth. And we're talking about a whole range of protections here. Article 15 says no discrimination. Article 24 protects children from being forced to work. And just look at Article 21, the right to life. The courts have interpreted this so broadly. It's not just about breathing, it's about living with human dignity. That includes things like your right to privacy, your right to shelter, even your right to a speedy trial. It's incredibly powerful. All right, so we've got these huge foundational rights. But what about the nitty-gritty? The laws that cover contracts, sales, employment, all this stuff you deal with every single day. Where do they actually come from? In India, you can basically think of our laws coming from three main buckets. First, you have customs. These are old, unwritten rules that have just been followed for ages. Second, judicial precedent. That's just a fancy way of saying that when a higher court makes a decision, all the lower courts have to follow it. And third, the one we're probably most familiar with, is legislation. The official acts passed by Parliament, like the Companies Act or the GST Act. Now, when it comes to those court decisions, this is a really important distinction to get. Not every single word a judge says becomes binding law. The key part is what's called the ratio decidendi. That's the core legal reason for the ruling. That's what sets a binding precedent. Everything else is obiter dicta, just things said along the way. They can be persuasive, sure, but they don't carry the same legal weight. It's kind of the same with legislation. There's a pecking order. At the very top, you have supreme legislation. Those are the big acts passed by Parliament itself. But Parliament can't write down every single tiny detail, right? So it delegates the power to make the nitty-gritty rules to executive bodies. That's what we call subordinate legislation, and it always has to operate within the limits set by that main act from Parliament. Okay, so we have our rights and our laws, but what happens when people disagree? Well, before we assume everyone just runs off to a courtroom, it's really important to know about the alternatives. A really popular method, especially for businesses, is arbitration. You can basically think of it like a private court. The parties involved agree to let a neutral third party, an arbitrator, hear the case and make a decision. And that decision, which is called an award, is legally binding. It's just as enforceable as a judgment from a regular court. Then there's another option, conciliation. This is a much more informal process. Here, the neutral conciliator doesn't make a ruling. Instead, their job is to act like a facilitator, helping the two parties negotiate and find their own solution. Nothing is binding until both sides voluntarily agree and sign a settlement. All right, theory is great, but let's see how this all works in the real world. We're going to put everything we've learned to the test and solve a practical case study, exactly the kind of thing you might see on an exam. So here's the scenario. An employee, we'll call him A, is accused of theft by his employer. He goes through a whole court trial and is acquitted. He's found not guilty. But then, a little while later, his employer says he's found some new evidence and tries to start another case against A for the exact same theft. So here's the crucial question. Is that allowed? Can the employer drag A through the whole legal process a second time for the very same alleged crime? Well, the Constitution gives us a very clear answer, and it's right there in Article 20. This article protects us from what's known as double jeopardy. It's a simple but incredibly important principle. You cannot be prosecuted and punished for the same offense more than once.
So the verdict is in. The answer is no. A cannot be tried again. That second case is completely unconstitutional. His fundamental right against double jeopardy protects him from being put through that whole ordeal twice for the same offense, regardless of any new evidence. Case closed.
Okay, let's do a super quick recap of the key takeaways. First, the Constitution is the supreme law of the land. It's the blueprint for everything else. Second, your fundamental rights are not just suggestions, they are guaranteed and they are enforceable in court. And third, knowing that our laws come from customs, court decisions, and legislation gives you the toolkit you need to tackle real-world legal problems. So I want to leave you with this final thought. Learning this stuff isn't just about passing an exam. It's about understanding the legal DNA of Indian business. These principles are baked into every contract, every transaction, and every single corporate policy. So the real question is, now that you know the foundation, how will this legal blueprint influence every business decision you make from here on out?